Court calls a matter of people of the state of Michigan versus Marina Ann Kaskorkas, file number 22-6258FH.
For the record, Your Honor, I call on behalf of the people.
Harry Brown on behalf of Ms. Kaskorkas.
Ms. Kaskorkas, are you connected now?
Yes, sir.
Go ahead and start your video. Ms. Kaskorkas, we're here for a status conference and a final plea cutoff date. Have you had enough time to remain in contact with Mr. Brown about this case?
Your Honor, you gave me plenty of time. However, the communication was hard to come by.
Well, that's unfortunate, but as you started with, and as I'm determining, you have had plenty of time to make communications. You've had plenty of attorneys. So in light of your statements, I'm not changing anything with respect to how I'm proceeding. This is how I'm proceeding. Today is a final status conference. That's where the attorneys tell me about what preparations I need to be aware of for trial. It's also a plea cutoff. If you want to take advantage of a plea offer, you can. If you want to reject it, you can. To the court, it does not matter. But one of those two choices will be made today. Then the next choice will be after that. If you make the choice to accept a plea agreement, I'll determine whether or not I believe that you're guilty of a crime, and then I'll set the matter for sentencing. If you reject the plea agreement, I'm going to continue the case on for trial on May 24th, and I'm not going to consider any plea offers ever again in the future. Do you understand those two different options, Ms. Kaskorkas?
I do, Your Honor.
And in terms of how you want to proceed, how do you want to proceed?
I would like to take the plea offer. However, I am still extremely unclear as to what it. I understand that it is resistance and obstruction, but by what means is what I want to know, because.
Well, Ms. Kaskorkas, this isn't a question and answer session. This is a me asking you questions, not you asking me questions. So let me try to clarify it more. If you want to enter a guilty plea under whatever terms that the prosecutor and your attorney have negotiated and you agree to, you can. But you need to be aware that there's only one way that I will ever accept a plea from you or any other criminal defendant. That's if you tell me that you're guilty. If we're going to waste time and ultimately we get to the preeminent question and you tell me that you're not guilty, let's not waste our time. If you're not guilty, then you should have a trial and you should hold the prosecutor to the burden of proving your guilt. If you have questions about your guilt, then you should have that trial. If you want to take advantage of the plea offer, though, that's fine, but I'm not going to accept a plea if you're wavering or telling me that you're not guilty. So it's either that you are guilty and we can take a plea if you want to do that, or you're not guilty and we'll have the jury determine the issues. Again, to me, it doesn't matter, but you've got to make that choice. So which choice is it?
I'm so sorry I'm not trying to be difficult, but
I doubt it.
in order for me to understand if I am guilty or not, I need to have it more clear what exactly it is that I'm supposed to be, what it is that they're trying, that I'm guilty of. Because when I tried to talk to Larry about this, he couldn't give me a straight answer, and he just said resistance and obstruction. Resistance and obstruction.
Respectfully, it's not very difficult to understand. It's made less difficult, Ms. Kaskorkas, because these charges have been pending for the better part of 3.5 years. So let me read the charges to you. They will speak for themselves, because you either did the things that are alleged, which makes you guilty, or you didn't, and you're not guilty. You're entitled to a trial if you want one. You're entitled to waive that trial and enter a plea if you want to. But the claims could not be more clear. The claim is that on or about December 28th of 2021, and while you were in Otsego County, you did either assault, batter, wound, resist, obstruct, oppose, or endanger. That means any one of those: assault, batter, wound, resist, obstruct, oppose, or endanger Trooper Cole Wright, a police officer of the Michigan State Police that you knew or had reason to know was performing his or her duties. And with regard to count 2, that you did assault, batter, wound, resist, obstruct, oppose, or endanger any one of those: assault, batter, wound, resist, obstruct, oppose, or endanger Trooper Tyler Morse, a police officer of the Michigan State Police that you knew or had reason to know was performing his or her duties. It's an element of the crime that the officer, for example, was performing their lawful duties, and a knowing failure to comply with a lawful command is, by definition, resisting and obstructing a police officer. Those are the elements. If that can't create clarity for you, I cannot help you any further. because that's what the statute prohibits, and that's what the prosecutor alleges that you did. You either agree with the prosecutor under the terms of the plea agreement that you did one of those things, or you disagree. Again, I don't care which answer it is, but I'm not going to take more time to go over those intricacies because you've had 3.5 years to go over them prior to today's date with multiple different attorneys on multiple different occasions. And I've had those discussions with you on multiple different occasions. Today is therefore the plea cutoff in a final status conference. And you get to tell me whether or not you want to take advantage of a plea offer because you're guilty, or whether or not you want the jury to determine the issues. Which one is it?
Can I just ask one more question?
You can ask it, but I don't know that I'll answer it. Go ahead.
Thank you. Who gets to say which one of those things I was guilty of? If I, because
If you're offering a plea, Ms. Kaskorkas, you do. Because if you're offering a plea, the only way I'll accept it is if you tell me that you're guilty in which one of those things you did. I'll either believe that's the point or I won't.
Thank you, sir. You did clarify that. Then I will take the plea.
Raise your right hand. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Mr. Brown, can you outline for the court the terms of the plea agreement as you understand them?
Your Honor, the terms of the agreement would be to plead to count 1 for a dismissal of count 2.
Accurate statement, Mr. Rolla.
It is, Your Honor.
Do you understand those terms, Ms. Kaskorkas, that if you plead guilty to count 1, the police officer assault, resist, or obstruct, the prosecutor dismiss count 2?
Yes, sir.
And understanding those terms, did you still want to proceed forward with that plea agreement?
Yes, sir.
If you plead guilty to count 1, police officer assault, resist, or obstruct, that is a felony offense in the state of Michigan with a maximum potential punishment of up to 2 years in the state prison system and or a fine of up to $2,000. Are you aware of that?
Yes, sir.
The benefit of the plea agreement is that if you plead guilty to that count 1, the prosecutor dismiss count 2, the other charge that was filed against you. Do you understand the benefit of the plea agreement?
Yes, sir.
Understanding both the benefit of the plea agreement as well as the maximum that you could face for police officer assault, resist, or obstruct in count 1, what is your plea to count 1?
Guilty, sir.
If you plead guilty, Ms. Kaskorkas, you don't any longer have any automatic right to appeal. If you had a trial and were convicted after a trial, you would have an automatic right to appeal. But when you enter a plea, your appeal rights become limited. You have to ask for what's called leave to appeal. The Court of Appeals could grant that, or they could deny it. Are you aware of it? Aware of that?
Yes, Your Honor.
If you plead guilty, you lose the right to trial. We have that set for you right now on May 24th. You also lose the trial rights that are associated with your trial. Those trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving you're guilty beyond a reasonable doubt. At your trial, you would have a right to have the witnesses against you appear and to see, hear, and question those witnesses. And you would have the right to have the court order any witnesses on your behalf to appear at the trial. You would have a right to testify at your trial. You would also have the right to remain silent at your trial and have the jury instructed not to hold that silence against you. You understand that you have those rights, but they're waived in this case if you enter a guilty plea? Yes, sir. You also, because you're giving up your right to trial, give up the right to challenge other things that you potentially could have challenged on appeal if you did have a trial. Do you understand that? Yes, sir. So for example, Ms. Kaskorkas, if the prosecutor brought in evidence that you thought was erroneous, it was prejudicial, and you had a trial, part of your appeal could have involved challenging that evidence that you thought was problematic. But since you're waiving and giving up your right to trial itself, you obviously can't challenge things that would have or could have happened at trial. Does that make sense?
Yes, it does.
Outside of the plea agreement that's been stated on the record today, has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And is it your choice to plead guilty?
Yes, sir.
The prosecutor claims that this offense happened back on December 28th of 2021. Do you believe that date is an accurate date?
Yes, I do.
On that date, were you present here in Otsego County?
Yes, sir.
While you were in the county, did you come across or come into contact with law enforcement officers?
Yes, sir.
Do you now know that one of those law enforcement officers was a Michigan State Police trooper known as Trooper Cole Wright?
Yes, sir.
And when you came into contact with Trooper Wright, was he in full uniform?
Yes, sir.
So did you know that he was a police officer?
Yes, I did.
And did you have reason to know that he was performing his duties at the time?
Yes, sir.
Why was he there?
Because Sam Kaskorkis, my ex-husband, I'd asked him to leave my property, and instead of doing that, he called the police and tried to report a domestic violence that did not occur.
So when police arrived, they were responding to an allegation of domestic violence, which means they were performing their lawful duties, correct?
Yes, sir.
When they were performing their lawful duties, did they give you some sort of an oral directive or command or tell you to do something?
No, sir.
What happened in your view that makes you guilty of one count of resist and obstruct?
I guess I tried to prevent them from entering my bedroom and prevent them from finding Mr. Rowe.
So Mr. Rowe was another individual in the home, correct?
Yes, sir.
And when the police officers responded, we already have this covered, but I want to make sure I understand. They were responding to an allegation of domestic violence and performing an investigation to find out whether that happened. Is that right?
Yes, sir.
As a part of that investigation, they were seeking to find out if there was another individual within the home. Is that right?
Yes, sir.
And based upon all the circumstances, because they were trying to find out if there was another individual in the home who may pose a threat to you or to Mr. Kaskorkis or to them, they had lawful authority to do that. Is that right?
That's what I've been told.
And that's what I made a finding of by way of a pretrial motion, correct?
Yes, correct.
And under those circumstances, you then attempted to prevent those officers from doing what they had the ability to do by stopping them from going into your bedroom after they saw Mr. Rowe, correct?
No, that's not exactly correct.
Well, I thought that's what you just told me, but why don't you tell me what actually happened?
No, they had, this was before they had seen him. They could not see him until after they entered my bedroom. But I tried to prevent entry into my bedroom.
When you tried to prevent entry, though, you understand and you agree that Trooper Cole Wright was performing his lawful duties. Is that accurate?
I've been at the last court finding, you determined that he was.
This is not about Ms. Kaskorkis, it's about you. I anticipated that this would be problematic. I've anticipated it because I've been seeing it happen for the last 3.5 years. So I'm going to be as blunt and plain as I can. This is the last opportunity. If the words come out that you're telling me you're not guilty, so be it, that's fine. And then we're gonna have a trial. This is the last opportunity to not have a trial. I don't mind having trials. The prosecutor doesn't mind it and Mr. Brown don't mind it. We need trials sometimes and you're entitled to it. If you want to not have a trial though, this is your opportunity. It does not matter to me. The jury can determine the issues and the jury might disagree with whatever my analysis is. But this isn't about what I determined. This is about what you believe. If you don't believe that you were violating the law, then tell me so and let's let the jury decide it. Did you violate the law?
At the time, I did not believe I was, but now I have come to the conclusion that as far as what you guys, that there was a special circumstance into why the police should have entry into that room, and that I violated that I denied them entry to the bedroom. I said, you can't go in there. I tried to stand between them and the door. I know I did that. I understand. I just really, sir, this has dragged on and I not to any benefit to me in my mental well-being. I want this to be done with, and I understand what I did. At the time, I did not believe that they had the right to do that, but I was wrong, apparently.
Well, that's not enough because you're quibbling and you're not taking responsibility are evident in every word you say. And apparently, what you guys say are not the types of things that I hear when I accept a guilty plea. So I reject the guilty plea. This matter will continue to trial. I had every reason to believe it would. my beliefs were now confirmed. This case will continue to trial on May 24th. Are the people ready to proceed?
Yes, Judge.
Mr. Brown, are you ready to proceed?
Yes, Your Honor. Could I have a moment to try to ask her a couple questions?
I'm going to give you the briefest of moments, Mr. Brown. I respect the position you're in, but this case has been way too long, and this is not the first discussion that I've had of this nature. This is about the fifth. And every time it gets to the same point, and so my patience is certainly wearing thin. I'll give you a quick moment, though, to ask some questions of your client.
Thank you. Ms. Kaskorkas, when Eric Rowe was in the bedroom and you knew that, correct?
Yes, sir.
Did you know he was not supposed to be there?
Yes, sir. I knew that he was in violation of his bond condition.
And when the police officer asked if he was in the bedroom, did you tell them he wasn't?
Yes, sir.
Because you knew he was not supposed to be there, and the police were looking for him, and you told them he was not there, do you believe that they had a reason to be there because he was?
I do now, sir. Yes, I do. I do believe that.
Did you believe it at the time? Because he wasn't supposed to be there, and the police were looking.
I was aware of it at the time. Yes, sir.
Thank you. Your Honor, I would ask that a factual basis be found.
Well, we're close, but we're still not there, because knowing that Mr. Rowe is there or not wanting him to be found is a state of mind. It's not a physical action. And so until I hear indication that there's a physical action of resist or obstruct a lawful command, I have no factual basis.
Ms. Kaskorkas, when they did see Mr. Rowe, they went in to arrest him, correct?
Yes, sir.
And were you trying to prevent that arrest once they saw him?
No, sir.
You were not telling them to get out of your home. They had no right to be here.
I did tell them to get out of my home, but I don't know if it was before that or after that. But like he said, enough.
Resolved by a jury. Ms. Kaskorkas, we're done discussing the matter. This matter will be resolved by a jury on each count on May 24th. I'm going to require that each party be present, each attorney be present by 8:30. Ms. Kaskorkas, that's the order for you as well. You must be present in the circuit courtroom in Otsego County no later than 8:30 in the morning on May 24th. Do you have any questions about that?
No, sir.
Mr. Rolla, anything further on today's record?
No, Judge, thank you.
Mr. Brown, anything further?
Further, Your Honor, thank you.
We'll see everyone at trial. Thank you.